File 23-21438-FC. People versus Michael Sean Mulholland. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Wagner?
Good morning, Amanda Wagner on behalf of the people.
James Daly on behalf of the defendant, Your Honor.
All right, and Mr. Daly, where do we stand with Mr. Mulholland's case today?
Your Honor, yeah, we're prepared to go to trial, but right now the only issue we have, excuse me, there's two files here. We have the file in circuit court, and there is a CPS probate court file. In that file, Judge Bala has ordered Mr. Mulholland to participate in an assessment for therapeutic parenting time with his son Blake. But the bond conditions right now prohibit him from being around minor children. And he needs to have that order amended in order to comply with Judge Sala's order. I'm just bringing it to the court's attention. His attorney on the probate matter is Ashley Hanson Grimes. They've already set a trial date in February for the probate matter. But as part of the bond conditions, or the part of the order imposed by Catherine Sala, he would be in violation of the order if he participated without a bond modification.
All right, Ms. Wagner, do people have any position on that?
Your Honor, I would request that a bond hearing be scheduled on that matter so that we have an opportunity not only to consult with the victims, but for the assigned prosecutor to respond meaningfully to that request.
Okay, just so I'm clear, Mr. Daly, the Judge Sala's order requires what?
Judge Sala's order requires that Mr. Mulholland participate in an assessment for therapeutic parenting time with his son, Blake, who is not an alleged victim in this matter. But again, the bond conditions in this court prevent him from any association with minors like that.
Your Honor, my other concern would be, and again, I'm not the assigned prosecutor on this case, but I don't know if the son is a witness in this case. It's obviously the sibling of the victim. So I don't think that it would be appropriate to grant that request right now without Ms. Arnold being able to weigh in on that.
All right, Mr. Daly, if you would like to arrange a hearing, it sounds to me as though that's something that shouldn't take too much time. I think we can get a hearing scheduled fairly quickly to address that issue. But I do think it would be appropriate to give the people a bit of advance notice so that they can do whatever investigation they feel appropriate, and if they want to make an argument for or against it, they can do that. So if you would be willing to contact the office and schedule a hearing, we'll get you in front of the court as quickly as we can.
I will do that, Your Honor.
Otherwise, you said you are ready to schedule this for trial?
Yes, Your
Honor. How many days do you think we will need to try the case?
I think we'll be probably taking 4 days. That's including a Wednesday, not having a full day there, picking a jury, those kind of things. The trial itself probably won't take 2 days.
I agree, Your Honor.
So all things included, you think 4 days?
I do, but that's a conservative estimate. I don't think it's going to be that long, but it will be if I don't plan for it.
Sure. Okay, let's see. So you see Francis there in the trial, or the trial.
Sierra's gonna help out, Judge.
Sierra, so we need a 4-day jury trial date.
Judge, I have the books. You said you needed a 4-day trial date.
Yes, please.
Would you like a firm date or as a backup?
Mr. Daly.
Whatever the court prefers, Your Honor.
Let's set it, if we have a backup available, let's do that.
We have a 4-day trial beginning November 28th. That is Andrew Olnhausen. Could back this up to that for all 4 days.
Mr. Daly, so that'd be November 28th, 29th, 30th, and December 1st.
That works for me, Your Honor.
Your Honor, that works for Ms. Arnold as well.
Okay. So let's set a final pretrial then for November 15th at 8:15. All right, the court will issue a scheduling order. I'm also going to issue an order for fingerprints because that has not been, we don't have fingerprint information in our file. So I'm going to issue an order for fingerprints. Fingerprints have already been taken. You just need to have that information transmitted to the court because that's not been done yet. And I need to have it done. So
He sent his fingerprints. I'll contact the jail and tell them to send it over, but he was in jail and fingerprinted while he was there.
again, I'm going to sign the order anyways. If it's been done, we'll just get the information that'll take care of it. So we will do that.
Thank you, Judge.
Okay, so the court will issue a scheduling order then. I think we're all set on this one unless Mr. Daly or Ms. Wagner, you have anything else?
I have
No,
nothing
Your
else.
Honor. Thank you.
Okay. All right, I have a jail device here. The camera is off and the microphone is muted. If there's someone in that jail room, could you please start the video and unmute the device. Mr. Glazer, you ready to proceed with Ms. Scholes?
Yes, Your Honor.
All right. Ms. Wagner, is this one that you can cover? Allison Scholes?
That's mine, Judge.
Oh, I'm sorry. I forgot, Ms. Muir, that you were here.
No problem.
Okay, then we are on the record in file 23-21524-FH People versus Allison K. Scholes. We are here today for a pretrial conference, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Muir.
B.B. Muir, on behalf of the people.
Jack Glazer on behalf of Allison Scholes, Your Honor. Excuse me.
All right, Mr. Glazer, where do we stand with Ms. Scholes' case today?
Your Honor, excuse me, she has met with the prosecutor's office and is going through the economic crime unit diversion program. They're not sure of the exact amount of the restitution. There's two different figures, but if it's one, it'll take her 6 months. If it's the other, it'll take her a year. So we'd ask to adjourn this out 6 months and see where we are at that point.
Okay, Ms. Muir, where do the people stand with respect to that request?
I would agree with Mr. Glazer. The only thing I would add is that she does have an initial diversion fee due of $585 on October 19th. And then we are looking into that restitution issue, which figure it's going to be. And there is a class online that she has to take, obviously, in the meantime. It's not just the financial requirement.
Right, she was aware of those.
Yeah, yeah.
We weren't sure what the restitution was.
Yep.
All right, so 6 months would take us into April. Let's go with April 3rd at 8:15.
That'll work, Your Honor.
All right, Mr. Glazer, would you prepare a stipulation for that adjournment?
Yes, Your Honor.
Okay, anything else we need to address today then?
No, Your Honor.
No, thank you.
All right, Ms. Scholes, your next date is April 3rd at 8:15. You can log in using all the same Zoom information you used today.
Okay, thank you, Your Honor.
All right, Mr. Glazer, do you need a breakout session with Ms. Betzer?
I don't
Sorry,
think.
Mr. Daly. Mr. Daly, do you need a breakout session with Ms. Betzer? You're muted, Mr. Daly.
Oh, Your Honor.
All right, we are on the record in file 22-21149-FH People versus Alexis Marie Betzer. We are here today for a pretrial hearing in this case, and we are today by video conference. First, let me ask, well, let's see, this is, first, let me ask Ms. Muir to place her appearance on the record.
B.B. Muir, on behalf of the people.
James Daly on behalf of the defendant.
All right, Ms. Betzer, are you able to hear us?
Yeah, he was trying to see if it was working. My bad.
Okay. All right, Mr. Daly, where do we stand with Ms. Betzer's case today?
Your Honor, she has a sentencing scheduled for October 27th at 8:15. At this time, she does not want to address the contempt of her court hearings for which she was picked up on. She wants to address those at her sentencing on October 27th. I've already explained to her that it won't make any difference, that these other matters still have to be addressed, but she would prefer to do it at her sentencing on the other matter.
What are you talking about?
When I came to the jail and talked to you about your contempt of courts, you told me that you did not want to plead on the contempt of
No,
courts.
I did not. I want to plead on it. Like, I don't even understand. This is a 93-day misdemeanor. And I have done 7 months on this charge, bro. Like, I just want to get this over with. I just want to get this done with. I just want to be done with this. Like, my charge is 93 days.
All right, Ms. Betzer,
And
Ms. Betzer.
I just keep coming back to jail, and I've done 7 months.
All right. Mr. Daly, do you want a breakout session with Ms. Betzer to determine
No,
what she wants to?
I've already discussed all of this with her. She engaged in drug use after she was released on last week.
I just want this stuff over with.
Right, Ms. Betzer, you're making this take longer than it needs to right now because you're interrupting. So you have 2 choices today. You can plead to the contempt, or we can adjourn the hearing on your contempt to the date of your sentencing.
I just want to plead. I'll plead guilty. I just want this stuff over. Sorry.
We're willing to enter a plea if that's what she wants to do, Your Honor, but that's not consistent with what she told me at the jail.
I never said I didn't want to plead.
All right, Ms. Betzer, would you raise your right hand, please?
Yeah.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
It's there.
Do you understand that the maximum penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes.
Are you satisfied with Mr. Daly and the advice that he's given you?
Yes.
Do you understand that you have a right to contest the contempt of court charge and to have a trial on it?
Yes.
You can put your hand down if you like. Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you
Yes.
understand that?
Yeah.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
However, you also have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charge that you committed contempt of court by testing positive for methamphetamine and morphine in a drug screen collected on September 18, 2023 at Lenawee Drug and Alcohol Monitor?
Guilty.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained.
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anyone threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
You had bond conditions in this case that prohibited you from using any controlled substances. Is that correct?
Yes.
Did you take a drug test on September 18, 2023 at Lenawee Drug and Alcohol Monitoring?
Yeah.
Do you agree that that test was positive for methamphetamine and morphine?
Yes.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Betzer's had full knowledge of her rights and she's had competent counsel. Mr. Daly or Ms. Betzer, do you prefer to have me pass sentence now, or do you want to wait until the sentencing on the underlying charge in this case on October 27th?
I want to be sentenced now, I guess. I don't understand, like, is there any way I can be sentenced sooner on my underlying charges? Like, I've already done the 93 days. All it is a 93-day misdemeanor.
All right, I understand what the underlying charge is and that it's a 93-day misdemeanor. You're before the court right now on a contempt for violating your bond conditions, which is separate from the sentence that you may get on October 27th when I sentence you for the underlying charge.
Oh, I'm sorry.
So do you prefer for me to sentence you now or for me to
No.
wait until October 27th?
No.
All right, so looking through the file, it is clear that Ms. Betzer has had difficulty complying with her bond conditions. This is the second time she's been before the court for contempt for violating bond conditions. She's previously failed to comply and failed to appear in court hearings, which she's pled guilty to. And so as a result of that, I think that a jail sentence is appropriate. So it's going to be the sense of the court that you serve 93 days in the Lenawee County Jail with credit for 2 days served. You can let the officer that's with you know that you are done with court for today, Ms. Betts.
Should be here. Don't be contacting.
All right, can you call for Jared Cole?
Thank you.
Mr. Murphy, I have Mr. Pontius here. Do you need a breakout session with him?
Yes, please, Your Honor.
All right, as soon as he gets his audio connected, I will set that up. Mr. Pontius, can you hear me?
Yes, I can hear you.
All right, I'm going to put you in a breakout session with your attorney if you give me 1 moment. Okay, Ms. Underwood, are you ready to proceed with Mr. Arrington?
Yes, Your Honor. Thank you.
Okay, we're on the record. in
Judge,
file.
Judge, I think this is going to be a plea that requires an amended information. And I've just requested that be done. So if you want to proceed, we can, but we wouldn't have that quite yet.
Okay, we will wait till we get that amended information then for Mr. Arrington. Ms. Underwood. I do have Ms. Page here.
I do, Your Honor.
Need a breakout session with her?
Yes, thank you.
Okay. Ms. Page, can you hear me?
Yes, I can.
All right, Ms. Page, I'm going to put you in a breakout session with Ms. Underwood.
Okay.
Chick says that, you know, if your friend Mr. Kennedy comes in from the jail, she and Phoebe want to talk to you about the case.
Okay, Ms. Hennigan, you wanted to discuss Mr. Kennedy's case without going on the record.
Yes, Your Honor. Ms. Meyer will be handling this for Mr. Sneed this morning, but he's currently in custody and new charges. One's been authorized, arraignment's not been taken care of yet. And there may be additional charges coming, and those charges were issued while he's on bond. So we don't anticipate we can really do anything this morning other than ask for a new pretrial date.
Do you know what his bond is on his new charges? Because I'm inclined to address his bond in these cases today.
Ms. Meyer, can you see what the bond is on the case at all?
Let me check. I might be able to. And then navigate this new system here.
I will say he was on tether with the current bond conditions. He was on tether for the current charges.
I'm aware of that. My concern is that he got charges while he was on the bond that I gave him. So I'm not convinced at the moment that his current bond is appropriate. Mr. Daly, do you need a breakout session with Mr. Coley?
Oh, Your Honor.
So that he doesn't know that yet because they haven't arraigned him. But I can tell you on this new file, it's not just one charge, it's a 6-count felony warrant. So I imagine his bond will be set pretty substantially on it. Been authorized as of yesterday, so maybe they'll arraign him today even.
Okay, Ms. Hennigan, and how far out were you looking for a pretrial?
Probably just about 3 weeks, Your Honor, so I could have time. I'm assuming, well, not assuming, but hoping that everything will be combined together. So if that could give them time to get all of this onto your docket together.
November 1st at 8:15.
I actually have a trial, oh wait. Yeah, I have an 8:30 show cause and then a trial right after that on the 1st, Your Honor.
About October 25th at 8:15.
Yes, I can make that work.
So October 25th at 8:15. Ms. Hennigan, will you do a stip in order for that adjournment?
I will, Your Honor.
Thank you, then I think we're all set unless you need something else.
You said you were going to address bonds, so I just wanted to make sure.
No, I'm not gonna, given what his bond is likely to be on the new charges, I don't think it's necessary for me to do that at this point.
Okay, thank you, Your Honor.
All right, Mr. Daly, are you ready to proceed with Mr. Coley?
Okay.
Okay, so we're on the record in file 21-20546-FH and 23-21261-FH, People versus Jared Michael Coley. The 21 case is set for a hearing on a probation violation. The 23 case is set for arraignment today on a bench warrant. Sir, you're Jared Michael Coley.
Yes, Your Honor.
Mr. Coley, have you received a copy of the bench warrant that was issued in the 2023 case?
Yes, I believe so.
That warrant alleges that you committed contempt of court by failing to appear for a pretrial on March 15, 2023 at 8:15 a.m. The maximum penalty for a contempt of court is up to 93 days in jail or $7,500 in fines. You do have the right to be represented by an attorney with respect to this hearing and any other hearings we might have in this matter. Mr. Daly does represent you on the underlying charge. Do you want him to represent you on this as well?
Yes, Your Honor.
All right, Mr. Daly, do you know how Mr. Coley would like to proceed today?
Yes, Your Honor, we'd like to plead not guilty at this time. And we would like to get these underlying charges back together and proceed with those. I'm not exactly sure now where the underlying charges are at. It's been a long time since we've addressed this issue. But I don't think the files have all been coordinated and are together to proceed at this time, Your Honor.
Okay, so we can set it out for a pretrial if you like on you can do October 25th at 8:15.
That's fine with me.
All right, we'll set both files then for a pretrial on October 25th at 8:15. Mr. Daly, could you do a stipulation in order for both files for the adjournments?
I will, Your Honor.
Okay. All right, Mr. Coley, you can let the officer that's with you know that you are done with court for today.
Thank you, Your Honor.
Thank you. Ms. Underwood, are you ready to proceed with Ms. Page?
I am, Your Honor. Thank you.
We are on the record then in file 23-21372-FH, People versus Amber Elaine Page. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Brenner for the.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Ms. Page this morning, Your Honor. Thank you.
All right, so Ms. Underwood, where do we stand with Ms. Page's case today?
I've discussed this matter with Ms. Brenner and Ms. Page, Your Honor. Ms. Page is prepared to make a $300 payment today, Your Honor. She is actively looking for another job, and she hopes to. She's got applications out. She hopes to hear something this week. Ms. Brenner and I have agreed, Your Honor, to set this matter out for a plea in 6 weeks. And it will probably be a plea then, but hopefully Ms. Page will have a job with income withholding by then, Your Honor. So that's where we are. So I believe the Attorney General's office will not object to a 6-week adjournment, Your Honor.
We're going to set a plea date for 6 weeks, Judge.
Yes.
Okay, so we'll set this then for November 15th at 8:15 a.m.
Thank
That
you.
is 6 weeks from today. So Ms. Page, you'll need to log back in on November 15th at 8:15 a.m. You'll use all the same Zoom information that you used to log in today.
Okay. I'll be happy to do the stipulation in adjournment, Your Honor.
Thank you, Rhonda.
Oh, thank you, Ms. Underwood.
Thank you.
All right, Ms. Page, you can go ahead and log out.
Thank you, Your Honor.
Mr. Murphy, are you ready to proceed with Mr. Pontius?
Yes, Your Honor.
All right, then, we are on the record in file 23-21490-FH, People versus Ryan Richard Pontius. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
BB Mirmap for People.
Matthew Murphy, appearing on behalf of Mr. Pontius.
All right, Mr. Murphy, where do we stand with Mr. Pontius's case today?
Your Honor, I was going to ask if we could set another pretrial on this matter. I am wanting to have some more time to speak with Mr. Fleming. In this case, I thought he was the one who it was appointed to or assigned to. I spoke with Ms. Arnold yesterday about the case, and that's what I was going to ask. There was some evidentiary issues I want to discuss with him and see what he wanted to do moving forward. I believe that we're still shy of needing to set a trial on this matter, so that's why I was asking for another pretrial.
All right, Ms. Muir, anything to address from the people side?
No, Judge.
All right, how about November 1st at 8:15?
That would work for the defense, Your Honor. Thank you.
Okay, Mr. Murphy, would you prepare stipulation in order for that adjournment?
Yes, Your Honor.
All right, I'm also going to enter an order for fingerprints. Our file does not have fingerprint information. So I'm going to enter an order for that. If they have been taken, we just need to have that information transmitted to the circuit court for our file. If they have not been taken, then Mr. Pontius needs to go back to the arresting agency, which looks like City of Adrian in this case, and have his fingerprints done.
Yes, Your Honor. I'll speak with Mr. Pontius about that further.
Okay, thank you. So we actually brought us into the
They emailed it, they said that's okay. I said no, wait, but
so we will take Okay, Mr. Malero, you have Mr. Pulsifer, is that correct?
That's correct, Judge.
He is here in the courtroom. Are you going to need a breakout session?
Let me look real quick. Not necessarily, Judge.
All right, Mr. Pulsifer, you come up to the table here. All right, we are on the record in file 23-21493-FH and 23-21494-FH, People versus Michael Clifford Pulsifer. We are here today for pretrial conferences in both of those cases. We are proceeding today partially by video conference. Mr. Pulsifer is present in person in the courtroom. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Wagner.
Amanda Wagner for the people.
Salvatore Malero on behalf of Michael Pulsifer.
All right, Mr. Malero, where do we stand with Mr. Pulsifer's cases today?
Judge, I'm going to ask to adjourn this one more time. Mr. Pulsifer incurred additional charges. There is a plea offer that I need to review with him in depth, and I did not yet do that. So that would be the basis for my request.
All right, Ms. Wagner, anything to address from the people's side?
No, Your Honor, no objection to the adjournment.
Judge, there is a show cause this morning too on Mr. Pulsifer for testing positive on a drug screen.
Thank you for that reminder, Mr. Coast.
When was it filed?
I'm looking for it now, Mr. Malero. I don't have that in my file at the moment.
Judge, I do have a copy of that if you'd like me to run that into you.
Could you let's see, give me just a second here. Is there one for both files or just one file?
It's on file 21493.
Yes, Mr. Post, if you could bring that in. I can't, it is not in the computer system and not in either file.
Judge Macro.
Yeah.
Scanner.
Could you scan?
Got one.
All right, Miss at the jail, you are Ashley Beam.
Yes.
Mr. Murphy, are you gonna need a breakout session with her?
Yes, Your Honor.
All right, Mr. Malero, if you hold on just a moment, I'm trying to get you a copy of the order to show cause.
Okay, thank you, Judge.
Okay, I just forwarded an email, Mr. Malero. All right, sir, you're Michael Clifford Pulsifer.
Yeah.
Mr. Pulsifer, Mr. Coase handed you a copy of a motion in order to show cause. Have you had an opportunity to review that? I need you to speak louder, please.
Yeah.
The motion in order to show cause alleges that you violated your bond conditions by testing positive for methamphetamines, amphetamines, and cannabinoids in a drug screen collected on September 28th at Illinois Drug and Alcohol Monitoring. The maximum penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You do have the ability to be represented by an attorney at the hearing on this here today and at any other hearings we might have on this matter. And if you can't afford an attorney, you can tell me that now and appoint one for you at public expense. You do have Mr. Malero representing you on your underlying charges in this case. You want him to represent you with respect to this issue as well. Did you understand my question?
Was it?
You have the right to be represented by an attorney.
Yeah.
With respect to this contempt issue and any other hearings we might have on it. Mr. Malero already represents you on your underlying charges. Do you want him to represent you on this as well?
Yeah.
Can you speak louder, please?
Yeah.
All right. Mr. Malero, do you want us to set up the iPad so you can speak to Mr. Pulsifer?
Yeah, yes, please, Judge.
All right. Mr. Pulsifer, if you'll follow the bailiff out to the hallway, he'll set up an iPad for you so you can speak privately to Mr. Malero. All right, Mr. Murphy, were you done in your breakout session? Ms. Beam was back here.
Your Honor, Ms. Beam never joined the breakout session. I don't know what's going on.
Oh, I apologize. Let me try that again.
It's the one.
Okay, Mr. Glazier, we have Mr. Lester here. Do you need a breakout session with him? You're muted, Mr. Glazier.
Yes, Your Honor.
All right, one moment.
DD-15, apparently a DD-15 session as well.
All right, sir, you're Mr. Lyles, correct?
Yes, sir.
Ms. Underwood, are you going to need a breakout session with Mr. Lyles?
Yes, thank you, Your Honor.
Am I still waiting on something?
Yes, Mr. Arrington, I'm sorry, we're waiting for an amended information for your case in order for you to be able to enter your plea. So as soon as I have that document, we'll get started.
Let me check on it right now. I don't know what the delay is. I'm sorry.
Okay, thank you. All right, Mr. Pulsford, you can come back and sit here. So we're back in the record in People versus Michael Clifford Pulsifer, files 23-21493-FH and 23-21494-FH. Mr. Malero, you had a chance now to speak to Mr. Pulsifer about this issue. You know how he wants to proceed.
Yes, Your Honor, we would proceed with stating mute on the allegation. I think this can be sent out for a confirmation test as to the methamphetamine and the amphetamine, which we would be requesting to be done and have this adjourned out to coincide with this pretrial date.
Okay, I don't think we established a pretrial date before I switched gears to the contempt. Mr. Miller, I'm sorry, is November 1st at 8:15 all right?
Is that a Wednesday, Judge?
It's a Wednesday morning.
Yes, that's fine.
All right, so we'll set it for November 1st at 8:15. Mr. Malero, can the prosecutor's office do stipulation and orders for that adjournment?
Sure.
All right. I'm sorry. Well,
I'm
let me
not
ask
gonna get away with
Ms.
it.
Wagner, Ms. Wagner, would you be willing to do a stiff in order since
Yeah, we certainly can, Your Honor. That's fine.
okay. All right, so obviously, there's an apparent issue at this point with respect to the positive drug test. We will set that out for the confirmation testing. Obviously, Mr. Pulsifer, you're going to need to continue to test as directed by Lenawee County Drug and Alcohol Monitoring. I'm just going to tell you now that if there are additional positive tests as we go forward and deal with this, the court will be dealing with that by issuing a warrant for your arrest rather than a show cause. So where we stand. So you're all set for today, sir.
Thank you, Your Honor.
Thank you, Your Honor.
I don't think I have any further cases with you. May I go back to Judge Anzalone's court?
Yes, thank you, Mr. Malero.
Thank you, Your Honor.
Mr. Murphy, are you ready to proceed with Ms. Beam?
Yes, Your Honor, I just had a question as to whether or not this was sentencing today, or if we were just handling the contempt and sentencing was at a later date.
I believe we're just addressing the contempt. Let me see if we have sentencing. Oh, yeah, so she failed to appear at sentencing. So as of right now, we don't have a sentencing date. So.
Yes, Your Honor.
All right, so we're on the record in file 23-21399-FH, People versus Ashley Nicole Beam. We are here today for arraignment on a bench warrant alleging a failure to appear at sentencing. Miss, you are Ashley Nicole Beam.
Yes.
Ms. Beam, have you received a copy of the warrant in this case?
Yeah. Yep.
Warrant alleges that you committed contempt of court by failing to appear at sentencing on September 21st, 2023. The maximum penalty for contempt is up to 93 days in jail or up to $7,500 in fines. You do have the ability to be represented by an attorney, or the right to be represented by an attorney with respect to this issue. And if you can't afford your own attorney, I can appoint one for you at public expense. Mr. Murphy already represents you on your underlying case. Do you want him to represent you on this contempt as well?
Yes.
All right, Mr. Murphy, do you know how Ms. Beam would like to proceed?
Yes, Your Honor. We'd just like to plead guilty to the contempt of court and continue the case to sentencing as quick as the court can schedule that. Ms. Beam still wishes to enter into drug court if she's still accepted into that. So we'd just like to get that moving along as quick as possible.
Okay, so Ms. Beam, will you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
Do you understand that you have a right to contest this contempt of court charge and to have a trial on it?
Yes.
You understand that throughout the trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes.
You have the right to have any witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all that?
Yes.
You are not required to testify at your trial, and no one can say anything about you not testifying and hold that against you in any way. Do you understand that?
Yes.
On the other hand, you also have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charge that you committed contempt of court by failing to appear at sentencing?
Guilty.
You understand that by pleading guilty, you're giving up your right to a trial and the right to have your lawyer's assistance at that trial, as I've already explained.
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anyone threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you will be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
So you were scheduled for sentencing this case on September 21st, 2023. Is that correct?
Yes.
And you did not appear here on that date for the sentencing hearing. Is that also correct?
Yes.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Beam has had full knowledge of the rights. She's had competent counsel. I will set this out for sentencing to go along with sentencing on the underlying case. You just a moment, I'm working on a date for you. Let's go with October 27th at 8:15 a.m.
Yes, Your Honor.
Is that a district court
Yes.
matter, Judge?
No, she had pled to possession of methamphetamine.
Okay.
We not have a PSI for her yet.
I don't believe we do.
I received one. It included a PSI from Hillsdale, a recent one from Hillsdale. I
Oh.
haven't, so I don't know if was there a mistake on that?
Probably not. I'm just, we have a new system, so maybe I'm just having issues finding it. What is the?
I was just-
date?
I'm sorry.
I'm sorry,
Sentencing date,
Judge. Yes.
October 27th.
Okay. Thank you.
All right, so Ms. Beam, you can let the officer that's with you know that you are done with court for today.
Okay, thank you.
Thank you, Your Honor.
All right, Mr. Glazer, are you ready to proceed with Mr. Lester?
Yes, I am, Your Honor.
All right, we're on the record in file 23-21516-FH, People versus Donald Raymond Lamont Lester. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Meir.
BB Mayor on behalf of the people.
John Glazer on behalf of Mr. Lester, Your Honor.
All right, and Mr. Glazer, where do we stand with Mr. Lester's case today?
Yeah, Your Honor, I'd ask to set it over for another pretrial. I guess I'd like to address bond. I've never met Mr. Lester until today.
We want people to see, and they don't have the track.
This was handled by Mr. Murphy
We're waiting on my information.
in district court.
All right, sorry, we had some background noise happening. What was that you said, Mr. Glazier?
I'd like to set it for another pretrial. I think there was an exam, so we need to get the transcript ordered on that anyway. But I would also like to address bond. I haven't met Mr. Lester until today, Your Honor. This was handled by somebody else in district court.
All right, what is it you would like to say about bond?
Yeah, Your Honor, I guess I'd ask for a PR, but there's a 3 charges here: possession of meth and a couple R&Os, and it obviously there's a habitual on it. He looks like he's got some receiving and concealing, escape, and aggravated burglary. Those are quite a ways back. They're over 20 years ago. There was a small amount of methamphetamine here, and it would be helpful to me if he was out to so that I can meet him in my office to review this case with him once I get the transcript. The other thing is, Your Honor, the information doesn't list an address for him, but he has an address. He's living here in Adrian, and in fact, his I think it's his son is in his senior year of high school here.
Right, Ms. Meir, anything people would like to say?
Just, Your Honor, obviously, given his criminal history and the fact that he was bound over and a habitual 4th offender, I think a PR bond would be too low. I don't know exactly what his bond is set at. I guess maybe it could be reviewed, but I don't think a PR is appropriate, just given that. He was also, and it was testified to an exam, that he had actively resisted and was combative to the officers when they attempted to arrest him on the methamphetamine. He also did give it a fake name at first because he had 2 active failure to appear warrants out of Monroe, one out of Monroe and one out of will be our court from Bliss.
They were traffic tickets, Your Honor, and those got dismissed. Only got one that I'm dealing with now.
Yeah, that's what he got arrested for, was some outstanding traffic tickets, failure to appear, I think.
That's why I moved back to Adrian. Plus, it's my son's last year of high school.
All right, well, I appreciate it's your son's last year of high school, but a bond needs to be designed to ensure Mr. Lester's appearance at court. Given the information that the court has available to it about various factors speak to that and some other things. So Mr. Lester apparently does live here in Adrian and has a local address. Apparently some kind of tie to the community through his son. I'm a bit more concerned that he's charged in this case with 2 counts of resisting and obstructing. He does have his past conviction in Ohio for escape, which speaks to.
I might say something real fast.
Mr. Lester, please don't interrupt me. I think those speak to his willingness to comply and the likelihood of coming back to court. So the bond is currently set in the amount of $20,000 cash or surety. I would agree with Ms. Meir at this point. I don't think a PR bond in this case is significant enough, is enough to satisfy me that Mr. Lester would continue to appear. I am willing to reduce that bond to a $5,000 cash or surety bond with a GPS tether. And I think under those circumstances, the court would be satisfied that Mr. Lester would appear for future court hearings. So that's what I'm willing to do with respect to bond. I will adjourn this out for another pretrial on November 1st at 8:15 a.m.
Mr. Olsen, I have to meet, because I got a letter from him as well that I have to meet twice. I think it's twice a week. I got a
I
letter.
can't understand. I need you to sit closer to the microphone, Mr. Lesser. I
I
can't
got a
hear you.
letter from Mr. Cross stating that I had to visit him twice a week if I made fine. That was another reason why.
I can't, Mr. Lesser, I'm sorry, but the microphone's not picking up your voice and I can't understand what you're saying.
Hello, can you hear me now?
That's better, yes.
Okay, I got a letter from Mr. Darren Cross, and I was instructed to meet with him twice a week while out on bond. That's the reason why I asked for a signature bond. I have no problem with it. I can't afford it. I don't have it in cash right now to be able to make bond. So I'll be sitting here idle, and I'm just trying to get out of here so I can go ahead and finish going back to work and getting ready to go back to school.
All right, I appreciate that. I've made my decision on bond, Mr. Lester, and that I'm not going to change that decision at this point.
Thank you.
Next pretrial?
November 1st.
Thank you.
Your Honor, does the court order the transcript from the district court?
Does not appear that has been ordered at this point, but we will do that.
You're gonna order that? Okay.
Okay, I don't know where that noise is coming from, but if you're not actively participating in a hearing, I need you to mute your device. I've got too much background noise happening that is interfering with our ability to create a record. Ms. Muir, do we have Mr. Arrington's amended information?
I'm calling on it right now again. I've asked for it a couple times.
All right, Ms. Underwood, are you ready to proceed with Mr. Lyles?
I am, Your Honor. Thank you.
All right, we are on the record then in files 22-20789-FH, that's set for probation violation hearing, and file 23-21433-FH, that's set for pretrial conference. People versus Jacoby Wayne Lyles. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Muir.
B.B. Muir, on behalf of the people.
Rhonda Underwood on behalf of Mr. Lyles this morning, Your Honor.
All right, Ms. Underwood, where do we stand with Mr. Lyles' case today?
Your Honor, it's my impression this case is going to be resolved. I just need to discuss a couple things with Mr. Bayanetto. So I would ask for just a brief adjournment, perhaps November.
Ms. Muir, anything from the people side?
No, no objection.
All right, so we are in this case at 78 days since the bind over. I will give one more adjournment, but I would be setting this for trial at the next pretrial if we don't have a resolution at that point.
Understood, Your Honor.
We'll set it for November 8th at 8:15.
And I'll be happy to prepare the stipulation in order, Your Honor.
Okay. All right, anything else we need to address today?
That's November 8th, Your Honor, or 18th?
November 8th.
18th.
No,
No, the 8th.
Oh, 8.
8th. Thank you,
Yeah.
everyone. The sound is bad.
Okay. All right, we are all set then. Mr. Lyles, you can go. I'm sorry, Mr. Jones, do you have anything to address in this case?
Judge, I just want to make sure we'll set the violation over to that date as well.
Correct.
Okay.
All right, so Mr. Lyles, you can go ahead and log out.
Is November 8th at what time?
8:15.
All right, thank you, sir.
Okay, thank you.
Yes, sir. You have a good one.
We should have that amended now. I just asked her to email it. I don't see it in my email yet, but she said it was done now. Do you have a copy, Miss Underwood?
I do, I'm looking right at my email and I don't have it yet.
Sorry, I'm trying to.
Oh, wait a minute. I take that back. I do have it. It's a new weird looking thing. I'm sorry.
Can you forward it to the rest of us? Because I don't see it yet.
Sure. Where does it say forward?
All right, everyone should have it now. I just got the email to Miss Piper and Miss Clark.
Thank you.
It does look a little different. I'm sorry. We're just trying to figure out how to do everything again.
All right, we are on the record in file 23-21396-FH, People versus Anthony David Arrington. We are here today for a pretrial conference. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Muir.
BB Muir, on behalf of the people.
Rhonda Underwood on behalf of Mr. Arrington, Your Honor.
All right, Ms. Underwood, where do we stand with Mr. Arrington's case today?
Your Honor, the offer is Mr. Arrington will plead guilty to count 2 of the amended complaint, Your Honor, attempted assault of a prison employee, and count 1, assault of a prison employee, and the habitual offender will be dismissed in this matter. He will be pleading guilty to the 2.5 year.
All right, Ms. Muir, is that a complete and accurate statement of the plea agreement?
It is.
All right, Mr. Arrington, can you raise your right hand to the extent that you're able? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
You are Anthony David Arrington?
Yes.
Mr. Arrington, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended complaint, attempted assault of a prison employee?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's giving you?
Yes.
Do you understand that the maximum penalty for that offense is up to 2.5 years in prison and or a $1,250 fine?
Yes.
And I'm sorry, Judge, that should just say $1,000 fine, but it's not applicable to Mr. Arrington anyway because he's in prison. But I think our staff just didn't know that. That should just be 2.5 years and or $1,000 fine.
Okay, thank you, Ms. Muir, for that correction. All right, Mr. Arrington, or I'm sorry, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Muir?
That's correct.
Ms. Underwood?
That's correct.
Is that also your understanding, Mr. Arrington?
What was that again?
Neither the prosecutor, defendant, or anyone acting on your behalf has discussed a possible sentence with the court. Do you understand that?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Arrington, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about September 21st, 2022 in Madison Township, Lenawee County, Michigan, that you did commit the offense of attempted assault of a prison employee?
Guilt.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Arrington to plead guilty?
None, Your Honor.
None, Your Honor.
Mr. Arrington, has your attorney promised you any particular sentence or estimated what your sentence would be?
That it'd possibly be under a year.
No.
Okay, do you understand, Mr. Arrington, that regardless of whatever conversations you may have had with Ms. Underwood, it's ultimately the court's job to sentence you, and I'll be making an independent decision that is not impacted in any way by the conversations you've had with Ms. Underwood?
Yes.
Do you understand that regardless of any conversation that you've had with Ms. Underwood, that the sentence I decide on could be more than what she told you?
Yes.
And you still want to proceed with entering your plea?
Yes.
Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, do you want to establish the factual basis?
Yes, I do. Thank you, Your Honor. Mr. Arrington, on September 17th, 2022, were you an inmate at the Gus Harrison facility located in Madison Township in the county of Lenawee in the state of Michigan?
Yes.
And you were an inmate at that facility, correct?
Yes.
And at that time, did you assault registered nurse Caitlin Bowker by grabbing her hand through the food slot?
Yes.
And you grabbed a hold of her hand and kept grabbing it. Is that true?
Yes.
And you knew she didn't want you to grab her hand.
Correct.
You didn't have her permission to grab her hand.
Correct.
I believe the proofs have been established, Your Honor.
Ms. Mayor, the people.
You knew that Miss Bowker was an employee of Gus Harrison?
Yes.
Okay, I'm satisfied with the factual basis.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Mayor?
It has.
It has,
Ms.
Your Honor.
Underwood? All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Arrington has had full knowledge of his rights and he has had competent counsel. I will refer this matter to the probation department for an update of, or for a pre-sentence investigation. And we will set sentencing for December 7th at 8:15 a.m.
Thank you, Your Honor.
Mr. Arrington, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
All right.
Okay, thank you. Then you can let the officer that's with you know that you're done with court for today, and thank you for your time.
All right, thank you.
Okay, Mr. Clement, I'm going to place you in a breakout session with Mr. Dagger Margosian, if you give me just a moment here. Mr. Clement, is there something on your screen asking you to join the breakout session?
Not that I see.
Give me just 1 second here. Let me try it again. Okay, Mr. Murphy, are you ready to proceed with Ms. Johnson?
Yes, Your Honor.
Okay, we are on the record in file 23-21482-FH, People versus Cassandra Nicole Johnson. We are here today for a pretrial in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Muir.
E.V. Miriam, have the people.
Matthew Murphy, PM on behalf of Ms. Johnson.
All right, Mr. Murphy, where do we stand with Ms. Johnson's case today?
Your Honor, at this time, we're going to request to set another pretrial in this matter. I need to speak with my client further and with Ms. Muir further about the situation, see if we can get something worked out, shorter trial. And I believe that right now that's the best step instead of setting a trial at this time. So if we could do that, that's what I'm asking.
Ms. Muir, anything from the people's side?
No objection.
How about November 8th at 8:15 a.m.?
Yes, Your Honor.
Mr. Murphy, would you do a stip in order for that adjournment?
I will, Your Honor.
All right, anything else we need to address with this case?
Nothing from the defense, Your Honor. Thank you.
Thank you then. Ms. Johnson, you can go ahead and log out.
Okay, thank you, Ms. Johnson. I'll give you a call when I get a chance, okay?
Okay, thank you.
If they have this Crabtree looking to do that, if it's available. So you cancel that because. Jason's son. Mr. Murphy, I do not have Caleb Rowell logged in. Do you know anything about him?
I do not, Your Honor. I will try to reach out to him if you don't mind, if you give me a few minutes for that.
All right.
Judge, I noticed on your docket, you have at 1:30, a contempt of court hearing for Dante Taylor. Do you know if you need a prosecutor for that? That's one of my cases that I have set for trial, and I didn't know he had a contempt of court.
Mr. Dagger Margosian is his attorney, and he's in a breakout session right now. Probably he might know better than I do what might happen this afternoon.
Okay. Are you able to at least tell me what the contempt is for?
Yeah, give me just a second to pull that file up.
Your Honor, I called and left a message with Mr. Rowell. Would it be okay if I logged on to Judge Anselm's court, try to clear out some cases there to give him some time?
All right.
Thank you, Your Honor. Hopefully he'll be returning the phone call within a few minutes. Thank you.
Oh, okay. So Mr. Taylor had a show cause for a bunch of failed PBT tests.
Okay.
And when he appeared at his show cause hearing initially for arraignment, he said that he was having difficulty with his machine, or his machine was not working properly. Mr. Coast, I think, confirmed that there was an issue with his machine and he's got a new machine. And so I think we put this on our docket real quick to see that he got a new machine and then he started testing properly. So
Okay.
Mr. Coast, you have any further information on that?
And he's still in Florida, Mr. Code?
Yeah, he is.
Okay. I just know the family will be asking me, so I wanted to make sure I have info. But that's
Okay.
fine. I don't think it's anything I would need to be there for.
Yeah, I think it's likely we're not actually going to have any kind of trial based on what I understand about the situation with respect to his device.
Okay. Thanks.
Yep. call Mr. or do you hear anything from Francis?
You know, I can even to
Look on Judge Anson's YouTube video over there.
This is Kelvin, Judge O'Savers office, calling for Mr. Mulat. Yes. No. With Judge Oldsaver? Because we don't have him on Zoom. We do not. Okay, great. Thank you. Thank you. Bye-bye.
Uh, Mr. Mulat, are you able to hear me?
I'm sorry, Judge.
What was your question? I apologize.
I was just asking if you could hear me.
I can hear you. Yes, sir. Yes.
Oh, our jail room is in use right now, but as soon as we have that available, we will call for Mr. Saunders.
Oh, no problem, Judge. I'm almost to Hillsdale County. We got plenty of time. No problem. Not a problem.
Okay.
Thank you.
All right, we are on the record in file 23-21541-FH, People versus Robert Anthony Clement. We are here today for an arraignment in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Meir.
Your Honor, if Ms. Meir is not there, my plan was to call her anyway to talk about the case. I'm wondering if we could just pass this matter briefly so I can call her.
All right, I can do that. Please be as quick as you can. I've only got one jail room, so
Okay.
We're waiting on this.
Understood. I'll be quick. Thank you, Your Honor.
All right, are we ready to proceed then with Mr. Clement?
Yes, Your Honor.
Yes.
All right, so back on the record in file 23-21541-FH, Ms. Muir, would you like to place your appearance on the record?
BB Mir on behalf of the people.
Honor Michael Dagger Margosian for Mr. Clement.
All right, we are here for an arraignment. So Mr. Dagger Margosian, does Mr. Clement wish to have the information read?
Your Honor, we'll waive any formal reading of the charges. For arraignment purposes, I guess we'll stand mute, but we do have a resolution, so I think we can enter that today. The court is ready for that.
All right, what is the agreement then?
Your Honor, the plea agreement as well as a proposed sentencing agreement is that Mr. Clement will plead guilty to count one, meth possession, dismissal of any habituals or supplements, and there also is an agreement that a district court case, misdemeanor, not in front of Your Honor, but pending in district court, that case would be dismissed as well. So that's the plea agreement portion of this case.
So you mentioned a proposed sentencing agreement. What is that about?
Your Honor, the sentencing.
So Judge, the people in this case would killabrew to a guideline sentence, and that we would agree that the guidelines at this point are 5 to 23 months.
And that the sentence would be the bottom end of the guidelines.
So there's a Killebrew agreement to 5 months.
There's a killabrew agreement to a sentence to sentence within the guidelines, and that the guidelines are 5 to 23.
Well,
so you're saying different.
Yeah, we're saying different things. Ms. Mayor, I think we agreed that the sentence would be the bottom end of the guidelines when we had talked about this case previously. And so now that we know that the guidelines are 5 to 23.
That's fine.
All right, so there's a Killebrew agreement to a sentence of 5 months. Is that?
Yes, I mean 6 in one hand, half dozen in the other. We agree that the guidelines will be 5 to 23. We also agree that the sentence would be the bottom end. So effectively, it is the 5-month sentence, Your Honor.
All right, Mr. Clement, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
Need to speak up a little louder, please.
Yes, sir.
Okay, thank you. You've heard the statement of your attorney and the prosecuting attorneys that your intention to plead guilty today to count 1, possession of methamphetamine or ecstasy.
Yes, sir.
You understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine.
Yes, sir.
Are you satisfied with Mr. Dagger Margosian and the advice he's given?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence before. Is that correct, Ms. Muir? Other than as we've discussed on the record this morning. Is that correct, Ms. Muir?
That's correct.
Correct. Your
Mr. Dagger, is that also your understanding, Mr. Clement?
Yes, sir.
If guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Clement, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about August 21st, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of possession of methamphetamine or
Guilty.
has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Clement to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Clement, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
Just the 5 months, sir. Whatever. Killigrew agreement.
All right. Is it your own choice to plead guilty today?
Yes, sir.
Mr. Dagger Margosian, would you like to establish the factual basis?
Yes, Your Honor. Mr. Clement, on August 21st of this year, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes, sir.
And at that time, did you possess methamphetamine?
Yes.
And did you know that the substance you possessed was methamphetamine?
I believe it to be, sir.
You didn't have a legal right to possess it?
No.
Okay. I'm satisfied, Your Honor.
Satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. Mayor?
It has.
Yes, Your Honor.
Mr. Dagger Margosian? All right, I will accept the plea that's been given understandably, voluntarily, and accurately. Mr. Clement has had full knowledge of his rights. He's had competent counsel. Other than as has been placed on the record, the court's not made any other agreement regarding possible plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. We'll refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for December 7th at 8:15 a.m. Mr. Clement, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
All right, bond will be continued and we'll see you back for sentencing. Thank you for your time.
Thanks.
Okay, you call for Mr. Saunders.
Yes.
Could we have Jason Saunders and judge, please? Thank you. Bye.
Okay, we can do Zachary. All right, we are on record in file 23-21391-FH People versus Zachary Richard Kranker. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. Courtroom is also open to the public. Ms. Mir, would you like to place your appearance on the record?
E.B. Mir on behalf of the people.
All right, and record should reflect this matter was set for a pretrial this morning at 8:15 a.m. There is a notice to appear and a certificate of mailing in the file indicating that it was sent to Mr. Kranker at his address that's on file with the court. I would also note that at the last hearing we had where Mr. Kranker was present, the court stated the date and time of this pretrial on the record, and Mr. Kranker was present to hear that. Additionally, Mr. Kranker has previously failed to appear in this case. The court has already extended him 24-hour or the 48-hour grace period based on his first failure to appear. He's failed to appear again this morning. He is not present in the courtroom and not logged into the Zoom session. I have had a Zoom session continuously running since before 8 a.m. and I have been monitoring the waiting room, and at no point has Mr. Kranker been logged into the Zoom session. So at this point, I am going to revoke and forfeit Mr. Kranker's bond. I am going to issue a bench warrant for his arrest, and I am going to set bond on that bench warrant in the amount of $25,000 cash or surety. Okay, Mr. Mawad, are you there? Your name, sir?
Morning, sir. Zachary Kinder. I called this morning. I had car problems on the way here. I had to wait for someone to come. I also got a letter in the mail saying that my attorney's not my attorney.
All right, can you come forward and sit at the table?
Yes.
All right, we are back on the record in file 23-21391-FH, People versus Zachary Richard Cranker. Court just moments ago was on the record in this case and indicated on the record that I would issue a bench warrant for Mr. Cranker's failure to appear because this matter was scheduled for 8:15 and it was approximately 20 minutes after 10. And we have not seen Mr. Cranker. Mr. Cranker is present here in the courtroom now. Sir, you are Zachary Richard Cranker.
Yes, Your Honor.
All right, so we are set today for a pretrial conference. Mr. Cranker, earlier this week, Mr. Sala, your attorney, filed a motion to withdraw from representation. And that was, we conducted a hearing on that motion on September 26th. I'm sorry, that was last week. There is a notice of hearing and a proof of service in the file indicating that motion and notice was sent to you. So the court moved forward with that hearing and granted Mr. Sala's request to withdraw from your case. You do have the right to be represented by an attorney at all hearings in this case. And if you can't afford an attorney, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes, Your Honor.
Do you want to be represented by an attorney?
Yes, I did.
And Mr. Sala had been appointed as a special public defender because of a conflict. Do you have the financial ability to pay for your own attorney at this time?
Not right at this moment.
All right. So the public defender's office had previously been assigned to represent Mr. Cranker. So to the extent I need to, I'm not sure I do, but I will continue that appointment. What's going to happen, Mr. Cranker, is they're going to have to assign a new special public defender because the regular public defender's office can't represent you due to a conflict. So what I'm going to do is set this out for another pretrial.
I'm sorry, I didn't interrupt you. I want to try to hire a lawyer.
Okay. You're welcome to do that. If you are able to hire a private attorney, that attorney will know what to do, but they just need to file a substitution of attorney replacing the public defender, special public defender from your case. So if you're not able to, then your new special public defender will just continue to represent you until such time as you're able to hire someone.
Okay.
Submit that substitution attorney.
Okay, thank you.
All right, so what I'm going to do is set this out for a pretrial on November 15th at 8:15 a.m. Mr. Cranker, the bailiff can give you our Zoom information so that you can attend by Zoom video conference. If you want to come up here, you just need to log in on Zoom. Just make sure you do it right at 8:15.
That'd be awesome, thank you.
And so other than that, you'll get a notice of the next hearing date in the mail.
Okay.
And hopefully we'll have your attorney issue resolved one way or another at that time.
Okay, awesome.
Okay, so you're all set for today then, other than Sergio, could you give Mr. Cranker a copy of our Zoom? Yes.
Thank you, Your Honor.
Okay, thank you, Mr. Cranker.
You have a good day.
Okay, Mr. Saunders, I apologize. We had Mr. Mawad, your attorney, logged in when we called for you. He is not logged in now. He did say that he was driving to Hillsdale, and I know that the cell reception between here and there is often not good. So I'm going to put you back. Well, I guess let me do this. I've got some other cases that I need to get to, I think I'm done, yeah. So we need that jail room. So we're gonna call for another person at the jail. They're probably gonna swap you out for a while. As soon as we have Mr. Mawad back, we'll call for you.
Yes, sir. Thank you.
All right. So if you call for Mr. Skin. All right, Mr. Glazier, we're calling for Patrick Skinner right now. Are you going to need a breakout session with him?
Hey, it's Kelly. Judge.
You are muted, Mr. Glazier.
We did not finish with Mr. Saunders, but we need his attorney. So
Is this for a sentencing today?
and then Patrick.
No, he's I think a
Okay.
pretrial and a violation of probation.
Okay.
Okay. They had it down as a sentencing and that's fine if it's just a pretrial. Yeah, I'll need a second to talk to him, Your Honor.
Okay, so yeah, it's a contempt of court. He had failed to appear for a violation of probation sentencing, so.
Okay, so you're not gonna do sentencing today.
No, I was not intending on doing the sentencing today. I think he was arraigned yesterday or the day before, and he wanted to have you here rather than Ms. Underwood.
That's fine. I'll need a copy of the sentencing to be sent to me. The PSI or whatever the recommendation is. I don't need it right now.
Yeah, all right.
Yeah. I don't know. Was in there.
All right, Mr. Murphy, any sign of Mr. Roll yet?
Unfortunately, no, Your Honor. I do apologize for his absence.
We are on record in file 23-21497-FH, People versus Caleb Emmanuel Roll. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McPhee.
Phoebe, Mayor, on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Rowell.
All right, record should reflect this was set for a pretrial conference this morning at 8:15 a.m. Mr. Roll is not present here in the courtroom. He is not logged into the Zoom session. It is now 10:38 a.m. Court has had a Zoom session running since before 8 a.m. this morning. I've been monitoring that this entire time. Mr. Roll has never logged in, and again, he's not present here in the courtroom. This does appear, from my review of the file, to be Mr. Roll's first failure to appear. So at this point, I will allow him the 48-hour grace period. Of course, not heard from Mr. Roll. Within that 48-hour grace period, I will issue a bench warrant for his arrest and set bond on that bench warrant in the amount of $25,000 cash or surety. Also revoke and forfeit his current bond.
Yes, Your Honor, understood. Thank you.
All right, thank you. Okay, good morning again, Mr. Mawad. We had just called for another person at the jail, so as soon as we're done with that one, we'll proceed with Mr. Saunders.
Very good, sir.